Bonus, additional concept. In Jalan Trading Company versus Mill Mazdoor Sabha, the court observed that the Payment of Bonus Act has four salient features, namely, it imposes a statutory obligation on an employer covered by this act to pay bonus to his employees. It defines procedure for payment of bonus according to the prescribed formula. It provides for payment of statutory minimum and maximum bonus as per scheme linked with the principle of set on and set off. It provides machinery for enforcement of the obligations created under the act. The Payment of Bonus Act extends to the whole of India. The first instance, the Act applies to every factory and every other establishment in which 20 or more persons are employed on any day during an accounting year. The appropriate government may apply the Act by notification in a gazette from accounting year as may be specified in the notification to any establishment or a class including a factory defined in Factories Act employing such number of persons less than 20 but never less than 10 persons. It is noted that once the Act applies to any establishment, it continues to apply to that establishment notwithstanding number of persons employed fall below 20 or 10. Now, accounting year. In relation to a corporation, the year ending on the date on which the books and accounts of the corporation are being closed and balanced. In relation to a company, the period in respect of which any profit and loss account of the company laid before it in AGM is made up, whether that period is a year or not. In another case, the year commencing on the first day of April, or if the accounts of an establishment maintained by the employer thereof are closed and balanced on any day other than 31st day of March, then at the option of the employer, the year ending on the day on which the accounts are so closed and balanced. Next, agricultural income shall have the same meaning as in Income Tax Act. Allocable surplus means in relation to an employer being a company other than a banking company which has not made the arrangements prescribed under Income Tax Act for declaration and payment within India of the dividends payable out of its profits in accordance with the provisions of Section 194 of that Act. 7% of the available surplus is in an accounting year. 67%. 67% of the available surplus is the allocable surplus. In another case, 60% of such available surplus. Appropriate government means in relation to an establishment in respect of which the appropriate government of Industrial Dispute Act. 1947 is the central government in relation to any other establishment, state government. Available surplus means the available surplus computed under Section 5. Award means the interim or final determination of any industrial dispute of any question relating thereto by any labour court, industrial tribunal or national tribunal. Next, salary or wage means all remuneration other than remuneration in respect of overtime work capable of being expressed in terms of money, which would, if the terms of employment expressed or implied were fulfilled, be payable to an employee in respect of his employment or work done in such employment and includes DNS allowance, that is to say, all cash payments by whatever name called paid to an employee on account of a rise in cost of living, but does not include 1. Any other allowance which the employee is for the time being entitled to the value of any house accommodation or of any supply of light, water, medical attendance or other amenity or of any service or of any concessional supply of food grains or other articles, any travelling concession, any bonus including incentive, production, attendance bonus, any contribution paid or payable by the employer under any law for the time being in force, any retrenchment compensation, gratuity or other retirement benefit payable to the employee or any ex gratia payment made to him, any commission payable to the employee. Explanation: where an employee is given in lieu of the whole or part of the salary or wage payable to him free food allowance or free food by his employer, such food allowance or the value of the food shall, for the purpose of this clause, be deemed to form part of the salary or wage of such employee. Next, allocable surplus, subsection 4. Allocable surplus is the particular percentage of the available surplus which is actually distributed among the employees as bonus. Subsection 4 lays down that if the employer has made arrangements prescribed under the Income Tax Act for the declaration of the dividends paid out of its profits in accordance with Section 194 of the Income Tax Act, the allocable surplus shall be taken as 67% of the available surplus. In another case where such arrangement under Section 194 of IT Act is not made, 60% of the available surplus shall be allocable surplus. Therefore, it is necessary to know as to how the available surplus is calculated. Next, available surplus, subsection 6. Subsection 6 defines the available surplus which is computed under Section 5 of the Act. Section 5 says, thus available surplus in respect of an accounting year shall be the gross profit for the year after deducting therefrom sums referred to in Section 6. Employee. An employee is defined as any person other than an apprentice employed in a salary or a wage not exceeding 10,000 per month. in any industry to do any skilled, unskilled, or manual, supervisory, managerial, administrative, technical, or clerical work for hire or reward, whether the terms of employment be expressed or implied. It may be noted the expression employee as defined in subsection is at variance from the workman defined in clause S of the section 2 Industrial Dispute Act. Thus, according to 2S of the ID Act, a workman including an apprentice whose salary does not exceed 10,000 per month, whereas under Payment of Bonus Act, an employee excludes the apprentice and the wage limit is raised to 10,000. In Payment of Wages Act, yet another expression, employed person, is used. Although all such persons are wage earners and are employed by their employers, they all would be working in the same establishment. Thus, it may be noticed that the difference in various definitions given in different labour laws create an hindrance in smooth implementation of the labour legislation. In the case of Anakapalli Cooperative Market Society versus Government of AP, court held that the Kolagaris are workmen employed by the petitioner and they are entitled to bonus under the Act. But weighmen and hamalis are not included. Various wage limits. It is pertinent to note that although the wage limit of an employee as defined in the Payment of Bonus Act was raised from 3,500 to 10,000 from 1993, but the monetary benefit of bonus are limited by wage up to 3,500 and under Section 12 of the Payment of Bonus Act, it is laid down that where the wages of an employee exceed 3,500 per month, the bonus payable to such employees under Section 1011 of the Payment of Bonus Act shall be calculated as if his salary is 3,500 per month. Thus, all employees drawing wages in wages slab of 3,500 to 10,000 per month would get same amount of bonus under this Act, treating their wages as 3,500 only. This is intended to avoid sharp difference in the amount of bonus to the employees drawing wages beyond the limit of 3,500. Therefore, wage differential, which is usual cause of hearth burning and migration among workers, is attempted to be controlled. Section 4. Calculation of gross profit. The gross profit derived by an employer from an establishment in respect of the accounting year shall, in the case of a banking company, be calculated in the manner specified in the first schedule. In any other case, be calculated in the manner specified in the second schedule. Next is Section 5. Computation of the available surplus. The available surplus in respect of any accounting year shall be the gross profit for that year after deducting therefrom sums referred to in Section 6, provided that the available surplus in respect of the accounting year commencing on any day in the year 1968 and in respect of every subsequent account year shall be the aggregate of A. The gross profit for the accounting year after deducting therefrom the sums referred to in Section 6, and B. An amount equal to the difference between direct tax calculated in accordance with the provisions of Section 7 in respect of an amount equal to gross profit of the employer for the immediately preceding account year and the direct tax calculated in accordance with the provisions of Section 7 in respect of an amount equal to the gross profit of the employer for such preceding accounting year after deducting therefrom the amount of bonus which the employer has paid or is liable to pay his employees in accordance with the minimum provisions of this Act for that year. Section 6. Sums deductible from gross profit. The following sums shall be deducted from gross profit as prior charges, namely, any amount by way of depreciation admissible in accordance with the provisions of subsection 1, section 32 of Income Tax Act, or in accordance with the provisions of the Agricultural Income Tax Law, as the case may be, provided where an employer has been paying bonus to his employees under a settlement or an award or an agreement made before 1965 May 29 and subsisting on that day after deducting from the gross profit notional normal depreciation, then the amount of depreciation to be deducted under this clause shall, at the option of such employer, such option to be exercised once and within 1 year from that date, continue to be such notional normal depreciation. An amount by way of development rebate or investment allowance or development allowance which the employer is entitled to deduct from his income under the Income Tax Act. C. Subject to the provisions of Section 7, any direct tax which the employer is liable to pay for the accounting year in respect of his income, profits and gains during that year. D. Any further sums as are specified in respect of the employer in the third schedule. Commentary. The bonus formula under Section 456. It is pertinent to note that the Payment of Bonus Act has replaced the full bench formula which was worked out by the Labour Appellate Tribunal in Rashtriya Mill Mazdoor Sangha versus Mill Owners Association, Bombay, 1962. The LAT formula was challenged before the Supreme Court as unconstitutional and arbitrary on account of the rehabilitation reserve permissible under that formula in Associated Cement Company versus Workman, 1959. And again in Ahmedabad Miscellaneous Workers Union versus Ahmedabad Electricity Company Limited, 1962. Thus, the Payment of the Bonus Act 1965 provided for a little different formula for the calculation of bonus payable to the employees in an accounting year. This formula is incorporated in Section 456 of the Act. According to this formula, starting point is the computation of the gross profit as per section 4. Thus, gross profit in respect of an accounting year has to be derived and computed A. In the case of a banking company in the manner specified in the first schedule of BR Act, in another case in the manner specified in the second schedule of the Companies Act. After computing gross profit as per procedure specified in section 4, the available surplus has to be calculated. Section 5 of the Act specifies the procedure for computation of the available surplus, and it says that the available surplus in respect of an accounting year shall be the gross profit for that year after deducting therefrom the sum referred to in section 6. It means, for the calculation of available surplus, the prior charges mentioned in section 6 have to be deducted from the gross profit in order to arrive at available surplus. The formula can be conveniently presented by the following equation: gross profit minus prior charges is equal to available surplus. Since the gross profit is computed under section 4, prior charges specified as sum deductible from gross profit under section 6 are deducted therefrom to arrive at the available surplus as computed in section 5. The formula can be explained as section 4 minus section 6 is equal to section 5. Nalikalla Ardista 5. Gross profit minus prior charges is equal to available surplus, which is 67% or 60% of the available surplus is allocable surplus. Now, as per subsection 4 of the section 2, allocable surplus which is actually distributed among employees as bonus would be 67% of the available surplus if the employer has made arrangements for the declaration of dividend in accordance with the section 194 of the Income Tax Act. In other case, allocable surplus would be 60% of the available surplus as calculated as per above mentioned equation. Section 7. Calculation of direct tax payable to the employer. Any direct tax payable to the employer for any accounting year shall be subject to the following provision be calculated at the rates applicable to the income of the employer for that year. Namely, in calculating such tax, no account shall be taken of A. 1. Any loss incurred by the employer in respect of any previous accounting year and carried forward, and any law for the time being in force relating to direct taxes. 2. Any arrears of depreciation which the employer is entitled to add to the amount of allowance for depreciation for any following accounting year, arrears subsection 32(2) of the Income Tax Act. 3. Any exemption conferred to the employer under section 84 of the Income Tax Act or of any deduction to which he is entitled under subsection 101 of that Act as in force immediately before commencement of the Finance Act 1965. Where the employer is religious or a charitable institution to which the provisions of section 32 do not apply, and the whole or any part of its income is exempt from tax under Income Tax Act, then with respect to the income so exempted, such institution shall be treated as if it were a company in which public are substantially interested within the meaning of that Act. Where the employer is an individual or a Hindu undivided family, the tax payable by such employer under Income Tax Act shall be calculated on the basis that the income derived by him from the establishment is his only income. Where the income of any employer includes profit and gains derived from the export of any goods or merchandise out of India, and any rebate on such income is allowed under any law for the time being in force relating to direct taxes, then no account shall be taken of such rebate. No account shall be taken of any rebate other than the development rebate or investment allowance or a development allowance or a credit or relief for a deduction not hereinafter mentioned in this section, and the payment of any direct tax allowed under any law for the time being in force relating to direct taxes or under relevant annual finance act for the development of any industry. In the case Bharat Containers vs. Engineering Workers Union, 1998, it was held that where the notional amount for payment of direct taxes has not been shown, such amount also should be calculated for the purpose of bonus. Section 8. Eligibility for bonus. Every employee shall be entitled to be paid by his employer in an accounting year bonus in accordance with the provisions of this Act, provided he has worked in the establishment for not less than 30 working days during that year. Commentary. Under Section 8 of the Act, it is laid down that every employee who has worked in the establishment for not less than 30 working days in any accounting year shall be entitled to be paid bonus by his employer for that accounting year in accordance with the provisions of this Act. Further, it is to be noted that although such employee who has worked for minimum 30 working days is eligible to receive bonus, but his amount of bonus would proportionately be reduced in accordance with the Section 13 of the Act if he has not worked for all the working days in an accounting year. It means that if he has worked for half the working days in an accounting year, he would get half the amount of bonus payable under this Act. Similarly, if he has worked only for 1/4 of the working days in an accounting year, his amount of bonus would be 1/4 of the bonus payable under this Act for that accounting year. Similarly, if he has worked only for 30 days and his amount of bonus would be reduced to 1/12 of the bonus payable under this Act if the accounting year consisting of a 12-month period. Again, computation of the number of working days for the purpose of Section 13 for proportionate reduction has to be done in accordance with the Section 14 of the Act, which says that an employee shall be deemed to have worked on days on which he has been laid off, he has been on leave with wages, he has been absent due to temporary disablement caused by an accident out of and in course of his employment. The employee has been on maternity leave with wages during that accounting year. Thus, eligibility of the employee to receive bonus is determined in accordance with Section 8, but the actual amount of bonus payable to him is to be determined with reference to and in accordance with Section 13 and 14 of the Act. Section 9. Disqualification for bonus. Notwithstanding anything contained in this Act, the employee shall be distinguished from receiving bonus under this Act if he is dismissed from service for fraud, riotous or violent behavior while on premises, theft, misappropriation or sabotage of the establishment. Commentary. Section 9 of the Act deals with the disqualification of an employee to receive bonus. It lays down that an employee shall be disqualified from receiving bonus if he is dismissed from service for 1. Fraud, 2. Riotous or violent behavior, 3. Theft, misappropriation or sabotage of any property. It is worth mentioning here that in order to disqualify an employee, it is necessary that he is dismissed from service for the reason mentioned in clause A, B and C. If the employee is not dismissed from service but is punished with a lower punishment or suspension, then he is not disqualified. Even pending inquiry for such an offence also, he cannot be disqualified unless the inquiry is concluded and the employer in consequence thereof has actually dismissed the employee from service. Therefore, dismissed from service on account of specified causes only would disqualify an employee from receiving bonus under this Act. In the project manager ONGC versus Shyamkumar, the court held that where an employee is suspended, it cannot be said that he did not work for establishment as is normally understood. If the employee is dismissed from service but he challenged the dismissal and got the dismissal set aside by the court, he would become eligible to receive bonus. In Ahmed Hussain versus Management of Swadeshi Cotton Mills, Pondicherry, the claim for bonus was made after the order of dismissal was set aside. The Labor Court rejected the claim for bonus on impugned order. The Division Bench of Hyderabad High Court set aside the impugned order of the Labour Court and held that if the order of dismissal is set aside, the employee cannot be disqualified from receiving bonus. First, he has to be an employee before he can fight for bonus. Section 10. Payment of minimum bonus. Subject to the other provisions of this Act, and every employer shall be bound to pay every employee in respect of accounting year commencing on any day in the year 79 and in respect of every subsequent accounting year a minimum bonus which shall be 8.33% of the salary wages earned by employee during the crossing of the year or 100 rupees, whichever is higher, whether or not the employer has any allocable surplus in the accounting year, provided that where an employee has not completed 15 years of service at the beginning of the accounting year, the provisions of this section shall have the effect in relation to such employee as if for the words 100 rupees, the words 60 rupees were substituted. This is one of the salient features of the Payment of Bonus Act, which imposes a statutory obligation on the employer to pay a minimum bonus of 8.3% of the salary or wage earned by the employee during the accounting year, or whichever is higher. This statutory bonus is payable by the employer irrespective of the fact whether or not the employer has any allocable surplus in the accounting year. In other words, even in case of a loss also, the employer is obliged to pay minimum bonus as a statutory duty imposed upon him by the Act. However, in case of employees below the age of 15 years, the minimum bonus age is 8.33% or 60, whichever is higher, is payable. In Jalan Trading Company versus Mill Mazdoor Sabha, Supreme Court observed that the power of Parliament is to fix minimum bonus cannot be questioned, because the object of the Act is to provide a equitable distribution of surplus profit between the three factors of production. It flows from jurisdiction over industrial labour dispute, welfare of labour. Legislation is therefore neither a fraud nor a constitution nor is culpable exercise of power. In case Messrs. J.K. Acrylics versus Union of India, the court held that where the Payment of Bonus Amendment Act 1995, replacing the Amendment Act of 1993, was challenged on the ground that it cannot have retrospective operative. The employer has no right to say that his liability to pay bonus cannot be retrospectively enlarged. In J.K. Gankelwalkar Group of Maharashtra, the court observed option to pay compulsory minimum bonus is subject to claim for insurance under Section 26. However, the payment of compulsory minimum bonus cannot be avoided merely because there was loss in the concerned accounting year. The expression of financial position of the establishment in Section 36 is a comprehensive but inclusive loss suffered by the establishment and various other factors, the totality of which will picture the economic conditions of the establishment. In Midani Workers and Staff Union versus Mr. Ratul Limang, Hyderabad, held that a writ of mandamus will be issued compelling the performance of a statutory duty. Section 10 of the Act imposes a statutory duty in respect of industry or to pay minimum bonus to its workmen in respect of the allocable surplus. Section 11. Payment of maximum bonus. Where, in respect of any accounting year referred to in Section 10, the allocable surplus exceeds the amount of minimum bonus payable to the employees under the section, the employer shall, in lieu of such minimum bonus, be bound to pay to every employee in respect of the accounting year bonus which shall be amount of the proportion of the salary or wage earned by the employee during the accounting year, subject to maximum of 20%. subject to maximum 20% of such sugar or wage. In computing the allocable surplus under this section, the amount set off against the provisions of the section 15 shall be taken into account in accordance with the provisions of that section. This section was omitted in the year 1976 but was again inserted in the amendment 1980. It lays down that where in a accounting year the allocable surplus exceeds the minimum amount of minimum bonus payable to employees under section 10, then the employer shall pay to the employees bonus in respect of the accounting year, which shall be an amount in proportion to the salary or wage earned by the employees during that year, subject to a maximum of 20% of such salary or wages. In computing the allocable surplus under this section, the amount set on or set off under section 15 of the Act shall be taken into account. In pertinent to note that this is also a special feature of the Payment of Bonus Act as per the recommendation of the High Power Bonus Committee, which restrained the maximum limit of bonus payable under Act 2008. And any amount available to the allocable surplus in excess of 20% is carried forward for the next year and set on in gross profit for the next year, thereby protecting the interest of the employees and also the liability of the employer to pay bonus which would secured for the next year. In fact, the sanitary obligation of paying a minimum of 8.33% bonus is also linked with the scheme provided under Section 15 in relation to Alice or workland. Section 12. Calculation of bonus in respect to criteria employee, where the salary and wage of an employee exceeds the 3,500 rupees per month. The 500 beyond such employee under Section 10 or the case may be. Under Section 11 shall be calculated as if it was salary. Wage was 3,500 rupees per annum. The provision of Section 12 was intended to remove the sharp fingers in payment of bonus between the employee and getting a lower salary or a wages and employer receiving a high wage unit to 3,500. Such disparity in the amount of income and bonus is not conducive to peaceful industrial relations and workers would be discontinued. Therefore, Section 17 lays down that where there in lieu of Section 12 lays down that where the salary or wage of an employee exceeds 3,500 per month, the bonus payable to him under Section 10 or the case may be under Section 11 shall be calculated as under Section 10 or the case may be under Section 11 shall be calculated as if his salary is 3,500 per month. Thus, all such employees who are drawing in between 3,500 and 10,000 per month would get the same amount of bonus calculated on the basis of his salary 3,500 only. Proportionate reduction in bonus in certain cases, Section 13, where an employee who has not worked at all for all the working days in the accounting year, the minimum bonus of 100 rupees or a case may be 60 rupees of bonus is higher than 8.33% of the salary or wage for the days he has worked the accounting year should proportionately be reduced. After an employee who has worked for 30 years in accounting year is qualified to receive bonus under Section 8, the lie cannot be bonus. It is subject to minimum provisions of Section 13. Therefore, laid down the employee has not worked for all the working days as an accounting year, the minimum bonus of 8.33% payable to him shall be proportionately reduced. If the employee has worked out for half the total number of working days that consisted in the accounting year, yes, this amount of bonus would be reduced to half this person which other employee have worked with all the work days and would get. Section 14. Computation of the number of working days. For the purpose of Section 13, employee shall be deemed to have an establishment on any accounting year also on the days on which has been laid off under agreement or permitted by the standing orders on the national level, has been in love with salary or wages, has been absent due to temporary disablement caused by accident arising out of land. The employer has been on maternity leave with salary or wage during the accounting year. For the purpose of Section 13, the working days in respect of an employee would be computed by taking into account his absence on account of the following reasons, and he shall be deemed to have worked on the day in which he has been laid off, he has been on leave with wages, he has been shown absent due to temporary disablement caused by an accident arising out of and in course of employment, and an employee has been on maternity leave. Section 15. Set on and set off of allocable surplus. Where for any accounting year allocable surplus exceeds the amount of maximum bonus payable, should the employees in the establishment under Section 11 there, then the excess shall, subject to the limit of 20% of salary, wage or wage of the employees concerned in establishment and accounting year 17, be carried forward for being set up in the succeeding accounting year and so on up to inclusive of the fourth accounting year to be utilized for the purpose of payment of bonus in the manner prescribed in the fourth schedule. Where there is accounting year, just there is no available surplus or the allocable surplus in respect of that year falls short of the amount of minimum bonus payable to the employees in the establishment under Section 11, and there is no amount of sufficient amount carried forward and set on under subsection 1 which would be utilized for the purpose of payment of bonus. Because then such minimum amount of deficiency as the case may be shall be carried forward for being set off in the succeeding accounting year and so on up to and inclusive of the fourth accounting year in the manner specified in fourth schedule. The principle of set on and set off as illustrated in the fourth schedule shall apply to all other cases not covered by subsection 1 or subsection 2 for the purpose of payment of bonus side. Wherein in any accounting year any amount has been carried forward and set on or set off against under the section, then calculating bonus for the succeeding accounting year, the amount of set on and set off carried forward under the earliest accounting year shall be first be taken into account. Commentary. The scheme of set on and set off is another special feature of the Parliament of Bonus Act, which is incorporated as per the recommendation of the High Power Bonus Act Committee. In fact, the statutory obligation to pay a minimum of 8.33% and a maximum of 20% as provided in the section 10 and 11, respectively, is linked to the scheme of set on and set off. Section 15 lays down that where in an accounting year the allocable surplus is a huge amount, the employer shall not pay more than 20% of the wages as bonus, and any amount of such allocable surplus in excess of 20% shall be carried forward, subject to another 20% for the purpose of set on the next accounting year. If the next year also allocable surplus is a huge amount, again employer shall pay only 20% maximum bonus and carry forward any amount in excess of 20%, subject to another 20%. And set it on in the subsequent year. This is allowed for a maximum of 4 years. It may be noted that each year when excess amount is allocable surplus is carried forward after making payment of maximum bonus under section 11, this would ensure payment of bonus to the employees in the next year, and simultaneously liability of the employer to pay a bonus would be lightened, subsection 1. Similarly, the set-off scheme covers the negative financial position of the employer and lays down that where there is no available surplus or allocable surplus in respect of an accounting year, he falls short of every pay mouse. And also provide that for calculating bonus for an accounting year, amount which has been carried forward for being set on and set off should first be taken into account. Thus, it may be noticed that payment of minimum bonus in case of law or any other deficiency of allocable surplus is carried forward for being set off in a year which would lessen the financial burden of the employer, or he is eligible to set off such amount of statutory minimum bonus which he might have paid from his pocket as if it is set off in the next accounting year. Section 16. Special provision with respect to such an establishment. Where an establishment is newly set up, whether before or after commencement of this act, the employer of such establishment shall be entitled to be paid bonus under this act as in accordance with the provisions of 1A, 1B, 1C. 1A in the first 5 accounting years following the accounting year in which the employer sells the goods produced or manufactured by him or render services. As the case may be, from such establishment, bonus shall be payable only in respect of accounting year in which the drivers derive profit from such establishment, and such bonus shall be calculated in accordance with provisions of this act in relation to other year, but without applying the provisions of section 15. For 6th and 7th accounting years following the accounting year in which the employer sells the goods produced or manufactured by him or renders services, such as the case may be, from such establishment, the provisions of section 15 shall apply to subject the following modifications, namely, for the 6th accounting year, set on and set off as the case may be shall be made in the manner illustrated in the 4th schedule, taking into account excess or deficiency, if any, as the case may be, of the allocable surplus set on or set off in respect of the 5th and 6th accounting years. As for the 7th accounting year, set on or set off as the case may be and shall be made on the manner of illustrated in the 4th schedule, taking into account excess delinquency, deficiency, if any, as the case may be, of the allocable surplus set off in respect of the 5th, 6th and 7th accounting years. From the 8th accounting year following accounting year in which the employer sells the goods produced or manufactured by him and renders services, as the case may be, he is from the subcontinent. Provisions of section 115. Section 15 shall apply in relation to such establishment as they apply in relation to any other establishment. Explanation 1. For the purpose of subsection 1, an establishment shall not be deemed to be newly set up merely by reason of a change in the location, management, name, ownership. Explanation 2. For the purpose of subsection 1A, an employer shall not be deemed to have direct profit in any accounting year unless he has made provision for the year's depreciation to which he is entitled under Income Tax Act and, as the case may be, under agricultural income tax law. Arrears of such depreciation and losses incurred by him in respect of the establishment for the previous accounting year have been fully set off against the profits. For the purpose of subsection 1A, 1B, 1C, sale of goods produced or manufactured during the course of the trial run running of any factory or of the prospecting stage of any mine or oil field shall not be taken into consideration, and where any question arises with regard to such production, sigma manufactured decision of the appropriate government made on after parties a reasonable opportunity of being heard shall be final, and then the decision shall be final, shall not be called in question by any court or any other authority in the world. A provision of subsection 1, 1a, 1b, 1c shall, so far as may be applied to the new departments or undertakings or branches set up by existing establishment, provide that if an employer, in relation to an existing establishment consisting of different departments or undertakings or branches, whether or not in the same industry, set up at different periods, has before the 29th May 1965 been paying bonus to the employees of all such departments or undertakings or branches irrespective of the date on which such departments or undertakings or branches were set up, and on the basis of the consolidated profit computed in respect of all departments and undertakings or branches, then such employer shall be liable to pay bonus in accordance with the provisions of this Act to the employees of such department or undertaking or branches, whether set up before or after date on the date of the consolidation of profits, computed as follows. Commentary. The provision is intended to provide some breathing time to the new entrepreneurs who have newly set up their business to acquire sound footing in the business without having an obligation to pay bonus. The section also incorporates the recommendation of the High Power Bonus Committee in this regard. Thus, it is said laid down in front of the 5 years following the accounting year in which the employer new in business selling his goods, produced or rendered services, as the case may be, the bonus shall be payable only from the year in which the employer earned profit. It means that up to a period of 5 years, a new employer is exempted from liability of paying bonus under this Act, subject however to the condition that during this period of 5 years, if he earns profit in any year, he is obliged to pay bonus from that accounting year in which he has so earned. Further, once the Act applies to it continues to apply thereafter, irrespective of any loss in subsequent years. The provisions of Section 15 relate to set-on and set-off would not apply to such newly established establishment during the period of first 5 years. An establishment exempted from 16(1) from liability to pay bonus under this Act is not liable to pay even the minimum bonus under Section 10 to his employees. In CIWT Corporation, their workmen, Supreme Court observed that where there is a mere change of ownership of establishment, provisions of section are not retracted, such employer is not exempted. Purpose of the section is to give some time for the establishment newly set up to gain grounds and not the employer. The provision of set-on and set-off under Section 15 would apply to such new establishment for the 6th and 7th years following the accounting year in which the employer sells his goods in the manner prescribed in the 4th schedule, subject to condition laid down, clause 1 and 2 of subsection 1b. However, from the 8th accounting year, Section 15 would apply in the same manner as it is applicable to any other establishment, subsection 1c. It is also clarified that for the purpose of the Section 16, an establishment shall not be deemed to be newly set up merely by reason of a change in its location, management, name and ownership. For the purpose of subsection 1a, an employer shall not be deemed to have earned profit in any accounting year unless he has made provision for depreciation to which he is entitled to under the Income Tax Act or Agriculture Income Tax Law. Secondly, the arrears of such depreciation and losses incurred by him for the previous accounting year should have been fully set off against his profits. In respect of a factory during its trial running or any minor oil field in its prospecting stage, the goods produced and manufactured during such period shall not be taken into consideration for the purpose of subsection 1a, 1b, 1c of subsection 1. Any question with regard to such production shall be decided by the appropriate government after giving an opportunity to parties for representing their case. Such decision shall be final and shall not be called in question by any court under any authority. Explanation 3. Subsection 2 of Section 16 deals with new departments or branches of existing establishment. It is clarified that the provisions of subsection 1a, 1b, 1c shall apply to new government or branches set up by existing establishments, subject to condition that if such employer has been paying bonus to such employees and branches which are set up on any before 29th May 1965 day on the basis of consolidated profits computing in respect of all such departments and branches shall be liable to pay bonus to all employees of such departments and branches under this Act on the basis of such consolidated profits. Section 17. Adjustment of customary or interim bonus against bonus payable under the Act, where in any accounting year an employer has paid any puja bonus or other customary bonus to an employee, or an employer has paid a part of the bonus payable under this Act to the employee before the date on which such bonus becomes payable, then the employer shall be entitled to deduct the amount of bonus so paid from the amount bonus paid by him to the employee under this Act in respect of the accounting year, and the employee shall be entitled to receive only the balance. Prior to passing of the Payment of Bonus Act, there existed a practice of paying some customary or puja bonus by all employers, particularly in textile industries, Bombay, Ahmedabad, where workers were paid bonus on the occasion of the Durga Puja or Deepavali. Section 17 of the Payment of Bonus Act took cognizance of such customary bonus and laid down that if any employer has already paid any such customary or puja bonus before the date on which the bonus under this act becomes payable, he shall be entitled to deduct the amount of such customary or puja bonus from the amount of bonus payable under this act, and the employees shall not be entitled to receive only the balance. If such customary bonus is based on the service condition, also that bonus is not excluded from the purview of this section. Section 18. Deduction of certain amounts from bonus payable to under this act. Where an accounting year an employee is found guilty of misconduct causing financial loss to the employer, then it shall be lawful for the employer to deduct the amount of loss from the amount of bonus paid by him and the employee under this act. In respect of this accounting year, only the employee shall be entitled to receive balance if any. This section companion empowers the employer to deduct any amount of paid under this act if has suffered any loss account of the misconduct of the employee. However, such amount of loss on account of the misconduct of the employee shall be deducted from the same accounting year, and the balance, if any, shall be paid to the employee. The section indirectly ensures good conduct of the employees. Section 19. Time limit for payment of bonus. All amounts payable to an employee by way of bonus under this act shall be paid in cash by his employer. Where there is a dispute regarding payment of bonus pending before any authority under Section 22 within a month from the date on which the award becomes enforceable, in any other case within a period of 8 months from the close of the accounting year, provided appropriate government such authorities, appropriate government may specify in this behalf upon an application made to it by the employer and for sufficient reasons, by order extend the said period of 8 months to such further period, or periods are things fit. So, however, there could be total period so extended shall not in any case exceed 2 years. This section prescribes the time limit for which the employer is required to pay bonus under this act. In the first instance, bonus shall be paid within a period of 8 months from the date of. If there is no dispute pending before any authority under Section 22 of the Act, if any dispute relating to bonus as specified in Section 22 of this Act is pending before the authority, in that case, bonus shall be paid within 1 month from the date of which the award of such authority becomes enforceable and the settlement comes into operation. However, appropriate government is empowered by order to extend period of 8 months on application of the employer for sufficient reasons for any further period not exceeding 2 years. Section 20. Application of the Act to establish in public sector in certain cases. If in any accounting year an establishment in public sector sells any goods produced or manufactured by it or rendered in service in competition with an establishment in private sector, and income from such sale or services both is not less than 20% of the gross income of the establishment in public sector for that year, then the provision of this Act shall apply in relation to such establishment in public sector as they apply in relation to establishment in the private sector. Save otherwise provided in subsection 1, nothing in this Act shall apply to the employees employed by any establishment in public sector. Commentary. The Payment of Bonus Act initially did not apply to any establishment in public sector subject to certain conditions. The exemption was withdrawn in 76. Again, it is provided by amendment in 1980. The subsection 2 provided that nothing in this section shall apply to the employees employed by an establishment in public sector except as provided in the subsection 1 of this section. Subsection 1 of section 20 thus lays down that if in any accounting year an establishment in public sector sells goods or renders services in competition with the private sector, and the income from such sale of goods or services rendered or both is not less than 20% of the gross income of the establishment in public sector, then the provision of the Act shall apply to such establishments in public sector as they apply to a like establishment in a private sector. Section 21. Recovery of bonus due from the employer. Where any money is due to an employer by way of bonus from his employer under settlement or an award or an agreement, the employee himself or any other person authorized by him in writing in his behalf, or in the case of a death of an employee, his assignee or heirs may, without prejudice to any other mode of recovery, make an application to the appropriate government for the recovery of the money due to him, and if appropriate government may not make such authority, as appropriate government may specify in this behalf, or satisfy that any government so due shall issue a certificate for that amount to the collector, who shall proceed to recover the same in any manner as given in land revenue. This section provides a single procedure for recovery of any bonus due to an employee from his employer. It also lays down that if any amount is due to an employee by way of bonus from his employer under settlement or an award or an agreement, An employee himself or his authorized representative, or in case of death, his assignee legal heir may make an application to the appropriate government and any authority specified in this regard for the memory of amount due to him without prejudice to any other mode of recovery. If the appropriate government or the specified authority is satisfied that such amount of bonus is due to the employee, it shall issue a certificate for that amount in collector who shall recover the amount in the same manner as arrears of land revenue. Such application should be made within 1 year from the date on which the money becomes due to the employee from his employer. However, such period can be extended if the appropriate government is satisfied the applicant could not make such application within a period of 1 year for sufficient cause. By an explanation to this section, it is clarified that for the purpose of this section as well as 22, 23, 24, 25, the expression employee includes a person who is entitled to payment of bonus under this act but is no longer in employment. Thus, provision is identical to the definition of the workman and clause S of section 2 of Industrial Dispute Act, which includes a dismissed and discharged workman within the scope of the law. Section 22. Reference of dispute under this act. Where any dispute arises between the employer and his employees with respect to the bonus payable under this act, with respect to the application of this act to an establishment in public sector, then such dispute shall be deemed to be an industrial dispute within the meaning of the Industrial Dispute Act 1947, 14 or 47, or of any corresponding law relating to investigation and settlement of industrial bonus dispute in force in a state and proceed. Provisions of the act are, as the case may be, such low tariff, save as otherwise expressly provided, apply accordingly. Commentary. This provision is intended to resolve the difference in the definition of employee under the Payment of Bonus Act and the definition of workman under Industrial Dispute Act. It is pertinent to note that the expression workman in clause S of section 2 Act includes a person within the scope of a definition of workman if his wages does not exceed 1600 per month, whereas an employee under the Payment of Bonus Act as defined to include a person who draws his wages not exceeding 3600 per month. Does an employee drawing more than 1600 wages, strictly speaking, would not be considered as a workman under ID Act, and as such dispute between employee and employer cannot be considered as industrial dispute. Thus, within the meaning and scope of Section 2K of the ID Act, and the machinery provided for adjudication of an industrial dispute would have no jurisdiction to deal with such dispute. In order to recover the difficulty, it is provided in Section 22 Public Payment of Bonus Act, and any dispute between such employee and an employer shall be deemed to be industrial dispute under 47 ID Act. Provisions will apply accordingly. However, it is again important to note that in Section 22 of the Payment of Bonus Act, only two types of dispute are referred, namely dispute with respect to bonus payable under this Act, dispute with respect to the application of this Act to an establishment in public sector under Section 30 of the Bonus Act. Thus, the benefit of the deemed clause would be available in respect to the above mentioned two types of disputes. What about the other disputes arising out of the Payment of Bonus Act? Under this Section 39 Payment of Bonus Act, it is laid down that the provisions of this Act are in addition to and not in derogation to the Industrial Dispute Act. Thus, by virtue of this provision read with Section 22, all disputes arising out of the Payment of Bonus Act can be adjudicated by and under provision of the ID Act 1947, subject however to the exception such as expressly provided under respective acts. It is pertinent here to refer to a cause of Pappu. Bonus Act Part 2 Section 22 Case. It is pertinent to note here to a case of Pappu versus Raja Tile and Matchworks 1988, in which the court observed that the bonus is no longer a bounty. It is a right recognized by the statute and enforceable under its provisions. When it was noticed that a claim to bonus may not be enforceable as an industrial dispute under Section 10(1) of the ID Act, the Act made specified provisions for bringing those disputes within the purview of 10(1) of ID Act. The Act did not create any independent machinery for settlement of bonus dispute, but relied on provision of the ID Act for its enforcement. It cannot be assumed that the Bonus Act intended some of the provisions of ID Act alone to be applied to claim for bonus. The Act has not expressly or impliedly excluded the application of ID Act. Second case, in HB State Electricity Board and another versus presiding officer, it was observed that the Act has deliberately and conspicuously omitted to incorporate the concept of workman and instead has chosen to use the word employee, and that too in contrast with an apprentice. Section 8 would lend support to such liberal and wider interpretation. Since the dispute arising out of this Act are deemed to be industrial disputes, no civil court has jurisdiction to try such dispute. Next, Section 23. Presumption about accuracy of balance sheet, profit and loss account of the corporation and companies. The section is intended to avoid unnecessary inquiry into the correctness of the balance sheet or profit and loss account relating to corporation or a company, while deciding any dispute relating to the nature specified in Section 22 of the Act, subject however to certain conditions. It is laid down that if during the pendency of any proceeding relating to a dispute of the nature specified in Section 22, before arbitrator or a tribunal under ID Act, such authority may presume accuracy of any balance sheet or profit and loss account of a corporation or a company, subject to condition that such balance sheet or profit and loss account is duly audited by the Comptroller and Auditor General of India (CAG), or by auditors duly qualified to act as auditor of companies under Section 226 of the Companies Act 1956. In such a case, it is not necessary for the employer to prove the accuracy of such balance sheet or submit an affidavit to prove its accuracy. However, if the authority is satisfied that the balance sheet or a profit and loss account is not accurate, it may take such steps as it may think necessary to find out accuracy of such statements. Subsection 1. If any trade union or representative of the employees require any clarification with regard to any item in the balance sheet or profit and loss account, it may apply to such authority. If such authority itself is satisfied that the clarification is necessary, it may require the corporation or a company to furnish such clarification to the trade union or their representative. Corporation or company shall comply with such directions of the authority under subsection 2. Next, section 24. Audited accounts of banking companies not to be questioned. This section relates to accounts of a banking company. It lays down that during pendency of any dispute covered under section 22 of the Act, before the authority, if any accounts of the banking company duly audited are produced before it, the said authority shall not permit trade union or employee to question the correctness of that account. Section 25. Audit of accounts of employers not being corporation or a company. This section extends the provision of section 23 relating to presumption of accuracy to the accounts of an employer not being a corporation or a company, subject to condition that such accounts are audited by an auditor duly qualified. However, in case such account is not audited by such auditor, authority before whom the proceeding is pending is of the opinion that audit is necessary, it may direct the employer to get the accounts audited. Where employer fails to get accounts audited as required, and the said authority may, without prejudice to provisions of section 28 relating to penalty, get such accounts audited by the auditor as it thinks fit under subsection 3. When accounts are duly audited in accordance with the above section 2 and 3, the presumption of accuracy under 23 may be applied to such audited accounts as per subsection 4. The expenses of auditing under subsection 2 and 3 shall be determined by the authority, which shall be payable by the employer under subsection 5. Section 26. Maintenance of registers and records. Every employer shall prepare and maintain such register, record other documents in a form and manner as may be prescribed. Section 27. Inspectors. Appropriate government is empowered to appoint by notification in official gazette such persons as it thinks fit to be inspectors for this act. The jurisdiction may also be defined within which they have to exercise the jurisdiction as per subsection 1. Then powers of inspectors. For the purpose of satisfying himself that the provisions of the Payment of Bonus Act are complied with, inspector is empowered to 1. Require an employer to furnish such information as may consider necessary. 2. Enter premises of the establishment or connected place with such assistance as required, and require one found in charge to produce before him any accounts, books, registers or records for examination relating to employment of person, payment of salary, wages or bonus. See, examine the employer, agent, servant or other in charge to be an employee in the establishment. Next, make copies or extracts from the book, register or document maintained. He exercises other powers as prescribed by the appropriate government. Every inspector is deemed to be a public servant under IPC. Section 28. Penalty. If any person contravenes any of the provisions, penalty to any person who contravenes any of the provisions of the Act Section 29. Offences by companies. If a person committing an offence under this Act is a company, and the person in charge and responsible for conduct of business is found guilty and liable to be proceeded against and punished accordingly. The option for the person in charge is that he proves that the offence was committed without his knowledge, or that he exercised all due diligence to prevent the commission of such offence. if offence is committed by a company despite that. But if it is committed with the consent or connivance of or attributable to a neglect on the part of a director, manager, secretary or officer, such person shall be deemed to be guilty. Company means body corporate, director means includes a partner in the firm. Next, section 30, cognizance of offences. No court shall take cognizance of any offence under this Act unless complaint is made by or under authority of the appropriate government or an officer of that government not below the rank of Regional Commissioner of Labour. In case of central government, not below the rank of Labour Commissioner in case of state government. No court inferior to that of Presidency Magistrate or Magistrate First Class can try the offence. Section 31. Protection of action taken under the Act. No legal liability shall lie of any government or officer of the government for anything done in good faith or intended to be done in pursuance of this Act. 31A. Special provision with respect to payment of bonus linked with production or productivity. Notwithstanding anything contained in this Act, the section permits any bonus to be paid under any agreement, whether entered into before commencement of this Act or thereafter, subject to the condition that such agreement shall not deprive any employee or require him to relinquish any right conferred upon him under Section 10 of this Act, relating to statutory minimum bonus of 8.33% or maximum of 20%, as required under Section 11. In the case SG Pharmaceuticals versus Sarabhai Chemical Staff Association and others, 1999, it was held that there must be a specific agreement or a settlement for every year or specific years for payment of bonus. In the instant case, in view of the specific terms of settlement between parties and by virtue of the provisions of Section 10 and 31A of the Act, settlement in question was held not to be made the basis for determining the bonus for the relevant accounting year. In the case Workmen versus JK Jute Mill Company, Section 31A and Section 34 as amended were held not to be discriminatory. In the case Modi Stone Private Limited versus Modi Stone Employees Union, held that in the presence of a settlement to that effect, the bar under Section 34 Act does not at all arise in respect of employees drawing more than 1600 rupees wages per month. Next, Section 32. Act not to apply to certain classes of employees. They will not apply to employees related to LIC, those seamen defined under Merchant Shipping Act, employee registered under Dock Workers Act, employed by any establishment engaged in industry of central government or the state government, employed by Indian Red Cross Society, universities and education institutions, institutions like hospital, Chamber of Commerce, Social Welfare, employees of Reserve Bank of India, employees of IFCI, Finance Corporation of State Government, SFC, DICGC, NABARD, UTI, IDBI, SIDBI, National Housing Bank, other financial institutions other than banking company, employees employed by inland water transport. This section enumerates it is not applicable to employees of LIC, merchant shipping, dock workers and employees employed in industry of central state government. In the case Workmen, Bangalore Water Supply and Sewerage Board versus Bangalore Water Supply and Sewerage Board and others, held that board was not of a character of a local authority. It cannot deny its character as an establishment within meaning of Section 13B of the Act. All workmen employed by Bangalore Water Supply and Sewerage Board are entitled to bonus under Payment of Bonus Act. Employees employed by Indian Red Cross Society, others of like nature, universities, education institutions, hospitals, Chamber of Commerce, Social Welfare are not covered by this Act. This Act does not apply to them. Employees enumerated in clause 6 to 9 and subsection B to G of this section are also not covered. Next, section 34. Effect of laws and agreement inconsistent with the Act. Provisions of this Act shall have effect or notwithstanding anything inconsistent therewith contained in any other law. 35 is saving, 36 is power of exemption. Case Messrs. Fashion Electric Dry Cleaners versus Government of AP, it was held that there is no statutory obligation of an employer to set apart part of his profits of the previous years for payment of bonus in subsequent years. Profit of the current period can be utilized for the purpose of its own sustenance. Rejection of the petition by management to government for exemption from payment of bonus to their employees under 36 is not valid. In the case Phoenix Mills versus State of Maharashtra, held that where the mill applied for exemption under Section 36, the minister refused such exemption without taking into account relevant factors. Such order is not a proper order. So Section 36, what it says is power of exemption. If the appropriate government, having regard to the financial position, other relevant circumstances of establishment, is of the opinion it will not be in public interest to apply all or any of the provisions of this Act thereto, it may by notification in official gazette exempt for such period as may be specified. Subject to such conditions, it may deem fit such establishment from all or any provisions of this Act. Now, Section 38, power to make rules. Central government has power to make rules. 39, application of certain laws are not barred, save as otherwise expressly provided. It is clarified that the provision of Payment of Bonus Act, save as otherwise expressly provided, shall be in addition to and not in derogation of the Industrial Dispute Act 1947 and any other corresponding law